Desisyon ng ICC sa pila ni dating Pangulong Rodrigo Duterte na interim release para sa kasong crimes against humanity ilalabas ngayong hapon. Ilang Davaoeños umaasa na palalayan ng dating Pangulo pero kampo ng mga biktima ng war on drugs kampanting kakatigan sila ng ICC.
May malakas naman po siyang basihan sa batas yung ICC Rome Statute. Sa amin naman,
sa ospital na na-stranded sa loob kasama ng kanyang employer, stable na po.
Ilang kongresista naman abay binatikos ang 500 pesos Noche Buena budget ang DTI, may paglilinaw naman sa kanilang pahayag.
Wala po akong sinasabing ganun. Actually, it was asked of me kung 500 pesos. Then I said, it depends kung ilan po ang miyembro ng pamilya.
At sa ating showbiz, Sara Labati, pinalayas nga ba ng anak ng multi-billionaire na si Rocio Zobel sa isang after party sa BGC?
RMN Network News.
Mga kasama, sa detalye po ng ating mga balita, inaantabayanan na ngayon anumang oras sa ngayong hapon na maging desisyon ng International Criminal Court o ICC hinggil pa rin sa apila ni dating Pangulong Rodrigo Duterte na interim release o kaya naman pansamantalang kalayaan nito. Nakatakdang magsimula na ito ng proceeding ganap na alas 5:30 ng hapon oras dito sa Pilipinas. Posible na buod lamang na desisyon ang babasay ng Appeals Chamber kung saan nakalagay na ang mahalagang punto ng desisyon. Una nang sinabi ng kampo ni Duterte hindi dadalo ang dating Pangulo sa pagpresenta ng ICC sa desisyon kung saan tanging abogado niyang si Attorney Nicholas Kaufman ang haharap para sa kanyang depensa. Nitong Hunyo nga nang humiling si Duterte ng interim release sa ICC para sa kanyang kasong crimes against humanity. May karapatang humiling ng interim release ang mga defendants sa ICC dahil sa tinatawag na presumption of innocence until and unless proven guilty.
RMN Network News.
Kumpiyansa ang kampo ng mga drug war victims na hindi kakatigan ng Appeals Chamber ng International Criminal Court ang apilan na interim release ni dating Pangulong Rodrigo Duterte. Ay sa legal counsel ng mga biktima na si Center for International Law, Philippines Executive Director Attorney Gilbert Andres, unanimous ang naging desisyon ng pre-trial chamber ng ICC noong Setyembre na ibasura ang aplikasyon na interim release ni Duterte at matibay rin ang ebidensya na may paglabag ito base sa ICC Rome Statute.
well, malakas ang kutob ko. Kasi una naman, unanimous naman po yung decision ng pre-trial chamber sa pagbasura ng interim release application. Ikalawa, mayroon naman siyang matatag na basihan sa mga salita mismo ni Mr. Duterte, at sa salita mismo ng kanyang kaanak, kagaya po ni VP Sara Duterte. At ikatatlo po, may malakas naman po siyang basihan sa batas, yung ICC Rome Statute.
Sakali namang pabura ng ICC ang kampo ni Duterte ay may iba pa silang paraan para questionin nito.
Wala siyang apila kasi appeals chamber na nga yan. Ngunit mayroon pa po nito nasa Rule 118 po ng Rules of Procedure ng ICC kung saan pwede po mag-file po sa pre-trial chamber ng review. I-review. Pero yan po ay siguro mga 4 months from now. Kung mapapayagan yung appeal niya.
Tinig ng legal counsel ng mga biktima na si Center for International Law, Philippines Executive Director Attorney Gilbert Andres sa panayam ng DCXL RMN Manila.
RMN Network News.
Dumako tayo ng Davao mga kasama sa kaugnay pa ring balita. Ilang mga Davaoeño naman muling nanawagan na palayain na ang dating Pangulong Rodrigo Duterte. Mula sa Remin Davao may detalye, Radyoman Abi Bibera.
RMN Live Report.
Patuloy na umaasa ang mga Davaoeño na palayain na ng International Criminal Court si dating Pangulong at Davao City Mayor Rodrigo Duterte. Sa isang panayam ng DXDC RMN Davao, sinabi ni Miguel Banilad na malaki ang naging ambag ni Duterte sa pag-unlad ng Davao City at naging pangunahing prioridad nito ang seguridad ng mga Davaoeño. Dagdag niya, sa loob ng termino ni Duterte ay higit na pinatibay ang peace and order sa lungsod at nabigyang solusyon ng ilang isyu ng korupsyon. Samantala, sinabi naman ni Nuki Blaze na panahon na upang pauwiin si Tatay Digong.
specialty ng Tarlac. Palang Kalabaw. Yung pala daw specialty. Tarlac? Tarlac City. Pwede rin Luisita exit. Diplex. Residence. Pwede sa mga exit ng Luisita. Luisita exit. Marami rin sila iba-ibang yung mga sauce. Caldereta sauce, sinugo sauce, machucho sauce. Iba-ibang klaseng sopa.
Po. Wow. Magandang hapon po. Naku, medyo may delay lang. Parang uso din palang malit. 17 minutes na po tayong nakabantay. Pero ang alam ko po kanina ay nagpapapasok na rin naman doon sa gallery kasi, sa public gallery. Pwedeng pumasok yung publiko, first come, first serve. At merong kaming balita kasi pwede pong mag-gather sa labas ng ICC. Ang unang nakapag-apply po ng permit ay mga supporter po ni Duterte. Kaya ang Duterte Panagutin Europe ay tatry po nilang makapasok lahat doon sa mismong courtroom, doon sa public gallery. Yun po yung Duterte Panagutin Europe. Pero gusto ko pong kilalanin lang briefly yung nandito po ang Duterte Panagutin Philippines. Ang ating pong supporters ay, well, in full force. Kilalanin po natin dating commissioner ng Commission on Human Rights, si Roberto Totsi Cadiz. Hi, ito yung Totsi. Ang ating po former diplomat at kasama po namin sa Concerned Lawyers for Civil Liberties, at dating spokesperson ni Justice Sereno, si Attorney Jojo Lacanilao. Ito, former congressman at kilala natin bilang isa sa mga mambabatas ng Bayan Muna. Nandito po si Attorney Kaloy Zarate. At syempre, suportado po tayo ng National Union of People's Lawyers, which is one of the organizations. As represented by the President of NUPL, nonetheless, si Attorney Efraim Ray Cortez. And the members of NUPL, asa na ba? Magsitayuan tayo. Of course, si Attorney Lisa Clemente, si Attorney Julia Nagpalo, si Attorney Bettina Fortes, Bettina Carlos Tubison, Bettina Fortes, and UPL members. Maraming salamat. And because we mentioned UP, nagpapasalamat din po kami sa UP Institute of Human Rights. Nandito po ang isang lawyer nila, head of the legal officer. Head legal officer, si Attorney Raymond Ice Bagilan. Maraming salamat po. At my boss, former boss namin. My former boss, nandito pala si Attorney Glenn Dalito. Maraming salamat po sa
by the Pretorial Chamber of a warrant of arrest.
Ito po si Luz
Pursuant Article
Caranza.
68(1)B of the statute, a chamber arrest of a
statute
person
regulates
appears
the
necessary.
issuance by the Pretorial Chamber of a warrant of arrest. Pursuant Article 58(1)B of the statute, a chamber assesses whether the arrest of a person appears necessary. 1. To prevent a person from not appearing at trial. 2. To prevent a person from obstructing or endangering the investigation or the court proceedings. Or 3. Where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The Pretorial Chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The Pretorial Chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence. Regarding the first ground of appeal and the question of whether the Pretorial Chamber erred in law by relying on hypothetical and non-specific risks to find that continued detention is warranted, the Appeals Chamber recalls that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the Appeals Chamber observes that a determination shall be made concerning the possibility and not the inevitability that one of the events listed in Article 58(1)(b) of the statute will occur, and that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The Appeals Chamber notes that in its assessment of risks under Article 58(1)(b) of the statute, the Pretorial Chamber relied on this legal standard. Indeed, the Pretorial Chamber correctly referred to the standard that the assessment under Article 58(1)(b) of the statute concerns the possibility, not the inevitability, of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the Pretorial Chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)(b) of the statute. With regard to the Pretorial Chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)(b), subparagraph 2 of the statute, the Appeals Chamber notes that the Pretorial Chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the Appeals Chamber finds that it was not unreasonable for the Pretorial Chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the Appeals Chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the Pretorial Chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the Appeals Chamber recalls that there does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the Appeals Chamber considers that it is possible to discern how the pretrial chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the Appeals Chamber observes that this is only one of the factors that the pretrial chamber took into account to support its conclusion on Mr. Duterte's inclination to interfere with investigations against him, and more generally on the risk of Mr. Duterte obstructing or endangering the investigations or the court proceedings. For these reasons, the Appeals Chamber considers that the defense has failed to demonstrate an error in the pretrial chamber's assessment and weighing of evidence before it in the context of its consideration of the risk under Article 58(1)(b), subparagraph 2 of the statute. In relation to the pretrial chamber's reliance on the notion of a network of supporters, the Appeals Chamber recalls that it has considered that it is sufficient for a chamber to establish that it is possible that a suspect had the necessary assets to abscond, and that there is a risk that a suspect has the financial means to abscond on the basis of concrete evidence. The Appeals Chamber has also held that the existence of a support of network and financial means may be relevant to determining whether there is a risk that a person may evade justice or interfere with the investigation, and that access to the international contacts could provide the means to enable a suspect to abscond, whether or not there was evidence that the suspect would actually utilize such contacts. In the impugned decision, in determining whether Mr. Duterte posed a flight risk under Article 58(1)(b), subparagraph 1 of the statute, the pretrial chamber considered that he appears to have the necessary political contacts as well as to benefit from a network of support within the Philippines. The Appeals Chamber considers that contrary to the defense's argument, the pretrial chamber specifically outlined why it found that there existed a network of supporters in relation to Mr. Duterte, and for which reason this supported its conclusion that the risk under Article 58(1)(b), subparagraph 1 of the statute was established. In the view of the Appeals Chamber, the manner in which the pretrial chamber undertook this assessment was case-specific, as it took into account the specific circumstances of Mr. Duterte, amongst others, his position as former president of the Philippines and his recent re-election as mayor of Davao City in May 2025. It follows that the defense has failed to demonstrate that the pretrial chamber committed an error in assessing and considering Mr. Duterte's network of supporters for the purpose of its examination of the risk under Article 58(1)b, subparagraph 1 of the statute. Further, under the first ground of appeal, the defense argues that the pretrial chamber's alleged reliance on irrelevant considerations led to errors of law and fact. Regarding the arguments on the assessment of evidence and, in particular, the defense's contention that a number of factors relied on by the pretrial chamber were irrelevant, the appeals chamber notes that when assessing the risk under Article 58(1)b, subparagraph 1 of the statute, the pretrial chamber relied on several factors in support of its finding that such risk existed. It relied on a statement by Mr. Duterte, statements by others, Mr. Duterte's position as a former president of the Philippines and his recent re-election as mayor of Davao City, as well as the matter of the gravity of the alleged crimes and concomitant sentence in case of conviction. The appeals chamber observes that the defense does not explain why, in its view, these factors were irrelevant to the pretrial chamber's assessment. Without more, the defense has failed to substantiate that the pretrial chamber's reasoning and assessment were unreasonable. In the same vein, the defense fails to demonstrate that the pretrial chamber's reliance on Mr. Duterte's re-election as mayor of Davao City in its assessment of the risks under Article 58(1)b, subparagraph 3 of the statute was unreasonable. Moreover, with regard to the defense's contention that the pretrial chamber selectively cited facts and ignored others in the same items of evidence, the appeals chamber considers that the defense has failed to demonstrate how the fact that the pretrial chamber accorded weight to the statement from Mr. Duterte that it cited should result in the pretrial chamber's ignoring or attaching no weight to other statements. Regarding gravity and concomitant sentences in case of conviction, it is recalled that the appeals chamber has consistently held that these factors are relevant considerations in assessing the risk under Article 58(1)b, subparagraph 1 of the statute, as these are factors that may increase an incentive of a person to abscond. In the present instance, the gravity of the alleged crimes and the possibility of a lengthy sentence was but one of the factors the pretrial chamber took into account in its assessment of risks under Article 58(1)b, subparagraph 1 and 2 of the statute. And it looked at the specific allegations against Mr. Duterte. It follows that the defense has failed to demonstrate an error. Regarding the question of whether the pretrial chamber erred in fact by failing to give appropriate weight to relevant facts, specifically Mr. Duterte's health condition and its mitigating effect on the risk factors set out in Article 58(1)b of the statute as argued by the defense, the appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)b of the statute and may be a reason for a pretrial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case-specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state guarantees. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state guarantees. The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b) of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58(1)(b) of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed preferred conditions in a situation such as the one at hand. It did so against the backdrop of having found that all three risks under Article 58(1)(b) of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. Finally, the appeals chamber notes that the pretrial chamber reached its conclusions in relation to the risks enumerated in Article 58(1)(b) of the statute on the basis of a comprehensive assessment of the information before it. In the present case, having rejected the three grounds of appeal presented by the defense in the appeal brief, the appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing, Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will.
Mega Manila, Metro Manila. DCXL News Express.
That time check was brought to you by Bingo Plus. Bingo.
RMN Network News. RMN Network News.
Radyo mo nationwide. SED Testimonies. SED Testimonies. Pagmatuod sa kaayuhan sa SED Marketing Products.
2022, nagpa-laboratory ko sa ako ang blood chemistry. Kita dito sa result nga medyo taas ako ang cholesterol, blood sugar, creatinine, blood cholesterol ba. So, ang ako na lang limintin, katong panyawan capsule with garlic o katong panyawan plus. After 2 years kapin, so nakita dito sa result nga baba siya ang tanan akong blood kin nako. Ako si John Elenio, na ako nagtrabaho diri sa LGU Magsaysay, Davao del Sur.
SED Testimonies. SED Testimonies. Pagmatuod sa kaayuhan sa SED Marketing Products.
Alam niyo ba na simula edad 50 pataas, madami nang nagbabago sa ating katawan. Kaya importante na kasabay ng healthy food at exercise ay umiinom din tayo ng multivitamins na adjusted para sa edad 50 pataas. At yan ang multivitamins plus Mineral Centrum Silver Advance. Ang multivitamins plus Mineral Centrum Silver Advance ay may nutrients na complete from A to zinc na i-adjust ang level para sa mga edad 50 pataas. Tumutulong para sa healthy heart,
Tapuan na lang, ti. Pag-over na lang, ti. Kay, parang ko ba? Anay mo, aking rin? Bus or train? Na ako, pila ka minuto? 10 minutes? Mabalik sa Central Station.
Anyway, ikaw anong nabayan? Anong
It's not fair. It's not fair. It is nothing. All I want is...
Maawa kayo sa matanda. Isipin ninyo ang anak ninyo at ang lolo ninyo. Ayun ni Tatay Digong. Hindi na siya makasisigil sa sarili niyang paa. Mga kapasunan, naghihintay ang mga pamilya.
Here in Holland, this country, the international human rights is in this country. Our former president is old. He did nothing.
Hindi ka maging presidente with Abel.
Inalibing niya ang ama mo. Binangon niya ang pangalan ng mga Marcos. Yan ang ipinagpalit mo. Yan ang pinagbayad mo. You are paying bad return with Duterte family. Please, release him. Ang power nasa kamay mo. BBM. Hindi masama kung ipalaya-layasin mo si Tatay Digong. Isip sa bayad, sa paglibing ng ama mo kung may utak ka, may puso ka.
Papunta ba dito? Hindi.
Mabuhay si Tatay Digong. Please release. Let him go.
Maraming salamat po. Well, parating din po ngayon ang apo ni Tatay Digong, si Omar. Asa po natin si Omar para sa kanyang hospital.
Nandito ka.
Na bawat sabihin niya, mangyayari. Susunod sinabi niya na, tirahin natin yun. Ganon, naniniwala sa natin.
Oo, totoo.
Ganon. Kaya, but the defense failed to establish that this is not support na
This is the
kung
way
ano
we
sabihin
love.
niya.
Oo,
We are only
oo.
supporting him kasi he's doing good in our country. It's
Yes,
not because
yes.
he's telling us what to do o ano ginagawa natin
Oo.
sa kung anong gusto niyang pagawa sa atin. Yun ang nangyaring paniniwala ng chamber na masyadong influence, malakas
You
ang
look
influence
in a bad
pati
way.
siya, kung siya ipapakawalan, pwede siya magdikta sa mga followers niya.
Ano ba
The
yan?
one thing to prove is nanalo siya ng mayor sa
Oo,
Davao.
oo.
And that shows only na napakalakas ng influence niya.
Sir, direct to the point, sir. Kung si BBM Bongbong Marcos ang magsabi, i-alis si Tatay Digong. Maalis na yan.
Kasi sa akin nawala eh. Tingnan mo, sa akin to.
I'm 30 years old here in Netherlands.
Yeah.
80 years old, nobody sit in jail. Let them free. No, you are not agree with me because trilyon ang niwakaw ni BBM.
Yan pong dapat iwasan natin. The chamber thinks na
We are here in the same...
magugulo tayo, mag-create tayo ng problems.
Nobody.
No, hindi pa
The big heavy-handed President Marcos must be. One
Hoy,
word is
hindi
enough.
tayo kaaway dito.
Marcos is enough. Duterte must be released because he is the president. He is the big power. In Netherlands, 80 years old, must be out in jail. Let him free. You cannot come here.
Maybe 5-7 years. Ganito naman.
Hindi po binigyan ng...
Shorter than that. Sana naman longer than that. Limited time na lang meron. So, sana pinagbigyan na lang time para sa pamilya niya. Wala naman i-consider ang health niya. Wala rin. Hindi ko alam anong pang-i-consider nila. Ang age niya, yun lang ba?
The grandson. Binigyan yung apila na maging makatao o limansay.
Kung first time mo mapasok sentence, kalaki-laki nakasabi humanitarian court. Hindi ko alam saan banda doon sa appeals chamber nila na may humanitarian na reason para i-deny siya interim release.
Congressman Omar, what is your reaction on the changes?
Well, of course, it's a bit gloomy, especially with the weather right now. It's befitting. As you know, my grandfather is 80 years old. I don't see the risk. They're telling the defense team that they failed to see grounds on his interim release appeal. Half the time while we are talking, he doesn't even know why he's in there, in detention. The other half, he doesn't know that he's here. He's in the Netherlands. So, I don't see what they don't see. He's 80 years old. He's got maybe 5-7 years. I think it's better he should spend those time with his family.
Congressman, ano pong plano ng family ngayon na ganito po rin?
Well,
They are not listening anymore.
you can't just sit down lying doing nothing. Still continue the fight. And if all our supporters are still with us, this is not the end. This is still just a part of it. This is still the continuation of a fight to bring him home.
Well, anong oras po ang dalaw niyo sa kanya ngayon?
It's around 1:30.
Gulo naman po, sinabihan na siya ng mga abogado.
Alam nyo, usually kung pasok kami, it's all smiles. Ayaw namin ipafeel sa kanya na sad ang atmosphere. Pero sige lang, konting time pa man. Medyo naano lang ako sa decision kasi grabe tatlong grounds.
Kaluoy si tatay ka.
Kisadukan man yun natin. Highlight.
Si Manong ay ibigyo pa dyan kung ang kainap ko.
Highlight na daw. Highlight na highlight.
Ibayad naman ko din sila. Mayawa, mga gani.
Ginawa yung bisikleta ko parang. Malapit ka lang dito. 40? Layo naman.
Si Manong man yung ibigyo man tangan.
Tapos merong mag-sponsor na country, then the country itself will be blamed kung mawawala si Tatay Dick.
Hello, bakit nila i-ho? Bakit hindi i-release i-ho?
Please tell me your name. Hi, I'm Aldwin Villarta. Hi, I'm Aldwin Villarta. Yeah. Sorry? Aldwin. Aldwin? Yes. Villarta. Villarta. Yeah. Okay. And you represent the supporters of yes. Tell me, what is your reaction on this decision of the court?
Yes, of course, my reaction of this is very sad. It's very unfair because as we Filipinos, our culture look at it differently. But of course, the court looks at it as well on a different side. They see as if our support towards Duterte is a negative thing. However, they should not be looking at that. They should be looking at the support of the Filipino people, that we want him, not because he has power towards us or he has power to control us, but it is us willingly and that we are willing to actually support him because he has done so much. It's us giving back the love that he actually gave us. So that's how I see it. It's unfair, and that should not be the case, and that should not be the decision of this court.
It doesn't say anything to you that he is accused of the crimes against humanity. How do you reflect on that? You know, with all these people who died during his regime.
Yes, but the thing is, it doesn't have to be like that. I have the facts with me, actually. I have the facts with me. Where in fact, it is here, through the police report, even the CNN has reported about it. I will read on it because
Tell me, okay, you have your facts. Just tell me what is your reaction on.
It's not true. All the cases that are sent or all the cases that are being told about him is not true because we have the data and the data does not lie. We have them, and if anyone who actually needs all those data, we can give them. Data is a fact and facts is facts.
Okay. Thank you very much.
Thank you so much.
Thank you. Can you please just...
Nakapila na sila dyan.
This is from
18. Is rejected. It's in the fourth appeal. The third rejected. And then the last one is that, oh, maybe. The human sa
34.
He's a
Thank you so much. Yes.
Dumaan yung mga bangag. Hello? Saya kasi nagsisabot. Wala na pag-aminin, nagpapagwala. Kasi kakakalos pa rin ang upo, kaya wala na pag-asa.
Problema eh, bigit na yung time ng tatay.
Kaya nga eh.
Pag-asa na lang natin na yung mga nagiging time niya, magsaya siya.
Tayo yung kalaban natin ng
Yung mga opportunity natin taga Europe, pasiyahin siya. Kung makalabas siya dito, sa magsibagsakan. Yung kaligayahan na bibigyan natin sa kanya. Siguro pang-apat na punto, tumaas ang tourism nila dito. Ayaw din na ganyan.
Kaya yan, nag-usap niya. Punta lang naman ang mga sa youth. Beautiful hair.
Eh, nagkanta biyata mo?
Nag-cheer mo, nakukuya mo. Sagit na ko. Sagit na ko.
Sabi ko video.
Yung video ko pa i-share.
Anak mo guys? Oo.
Init pa siya galing.
Grabe kita biliwan. Ito po ang ginagawa. Yan po ang ginagawa. Medyo.
Kasi maganda daw yung paliwanag. Ano ba, may ka na rin?
Head spear, leader. Since 2017, I don't know if you heard about it. Kami yun, sabi ko. All over Europe. Dito pala sa atin.
Gam, ano siya po, sir? Kahit mo natutapin.
Ang prayer namin, kita namin mga taga-Europe sa tatay ko.
Okay, thank you.
Nakagawa pa naman siya nila. Nakagawa pa naman kasi ng taga-Switzerland lang. Gusto nung uwi siya. Sabi namin yung mga na yan sa Vietnam. Solid ba? Solid again? Hindi, good. Big brother, Godwin brother.
Yeah, but can you please Can you handle that in France? I did more yoga. Sorry, it's only okay? Thank you. Cheers. Bye-bye.
Pursuant Article 58(1)(b) of the statute, a chamber assesses whether the arrest of a person appears necessary. 1. To prevent a person from not appearing at trial. 2. To prevent a person from obstructing or endangering the investigation or